My name is Kendall Scott and I'm the manager for the Employee Relations Advice Centre here at CCI. The Employee Relations team take around 33,000 calls on employment matters every year, and typically a lot of those calls tend to be related to compliance, so what awards are we covered by, what are the minimum wages that we need to pay, but they can also include general human resource issues such as how do I performance manage a staff member, how do I deal with someone who's been off work and had a lot of absences, and a whole range of other issues. An underpayment claim is where an employee lodges a complaint, and that can be an informal complaint to their employer directly, that they haven't been paid the correct minimum wages that they should be receiving, or they can go to the Fair Work Ombudsman or Department of Commerce, which are the federal and state auditing bodies respectively, and put an underpayment claim through to those bodies who can come in and investigate a business to see if they have not paid their employees appropriately. When we talk about underpayment, what we're talking about is businesses failing to meet their statutory minimum obligations when it comes to pay. For employees that are award or agreement covered, that means meeting the terms and conditions when it comes to payment in those industrial instruments, and for award-free employees, it's at least meeting the minimum wage. For some employees as well, they might have a contract of employment that either sits above their award or their agreement, or if they're award-free, that provides a higher rate of pay again than what they would get in their award or their agreement. And sometimes underpayment claims can be failure to comply with that document as well. The risks associated with underpayment can be far-reaching. So it's not just simply the fact that employees haven't received the right rate of pay, and there's generally a need to make back payment for the difference that they haven't received in those circumstances. But it can also mean that a business is at risk of breach of award or agreement for that matter. And if that happens, the business can be at risk of incurring fines, and sometimes quite significant fines at that. For example, in the national system, if the business is a national system employer and they haven't complied with their award terms and conditions, they could be at risk of receiving fines of up to $54,000 for the business itself, or the individual owner or director potentially could incur fines of up to $10,800, and that's per breach. So if you have a number of employees that have been underpaid, or there's been multiple breaches of an award with respect to payments, so for example, one breach might be not paying the base rate of pay, another breach might be not paying casual loadings, and another might be not paying penalty rates on a weekend, they can quickly stack up. There are other risks associated with underpayment that are not directly related, but sometimes can result from them. So for example, if an employee raises a complaint with a business that they have been underpaid, and then the business takes action against that employee that causes them to have no option but resign, or the employee is terminated or demoted, for example, so actions that disadvantage them or injure them in their employment, it would be open to the employee to put in what we call an adverse action claim against the business, or if the employment is terminated, an unfair dismissal claim if they're eligible to do that. Those claims also carry significant penalties, and in the case of adverse action claims, potentially uncapped compensation as well. So they can be extremely expensive, and they can be claims made in addition to fines that can be incurred for breach of the industrial instrument. So they can get really expensive really quickly. The other issue, if an employee has a contract, for example, that provides a higher rate of pay than the award, if a business isn't complying with that, there's also the risk of breach of contract, and there's avenues to pursue those sorts of claims as well. With those claims, also compensation can be afforded to the employee, which can be unlimited. So they can get really expensive very, very quickly. The Fair Work Ombudsman is the federal government body that is charged with education and compliance when it comes to statutory minimum entitlements under employment law. So Fair Work Ombudsman So Fair Work Ombudsman, specifically in relation to underpayment claims, can investigate a business. They can require the business to produce records relating to an employee's pay. That might include things like pay slips and general records about time record keeping rosters, for example, so that they can assess whether the person has been paid correctly against their industrial instrument. So Fair Work, they also have the ability to come in and issue on-the-spot fines or infringement notices for failure to make records, and they can refer matters if there's a significant underpayment claim to the courts to deal with if they deem that appropriate. Fair Work Ombudsman do target particular industry sectors, especially if they've run a compliance campaign where they've been auditing businesses, usually in a particular geographical location, and they find that businesses in a particular industry, as a result of those compliance audits, that there's widespread underpayment or other issues relating to employment law there, will then subsequently go on to run compliance campaigns where they target industry sectors. There's certainly been quite a significant focus on franchise groups of late. There's been some significant media coverage of certain business types where underpayment has been particularly prevalent, particularly with respect to employees that are overseas workers on student working visas. What we're also seeing is Fair Work tends to focus on businesses that employ vulnerable workers, so businesses that engage workers with English as a second language, or employees that are younger, junior workers, or for some reason find it difficult to raise complaints. Certainly we are seeing that, and particularly with franchise groups, that seems to be a key focus at the present time. Fair Work inspectors initially will make contact with the business if they've received a complaint from an employee. So inspection or audit can be initiated either by an employee making a formal complaint to Fair Work, or Fair Work of its own initiative can just randomly go out and audit businesses. If a business is found to have underpaid its staff, it depends on how significant the underpayment is and how prevalent it is. Generally, if it's a minor underpayment and businesses are not resistant to rectifying the issue, quite often it won't be taken any further. But if it's quite widespread, or it's a significant underpayment, or the business has been negligent in taking steps to understand its statutory obligations in that regard, and particularly if it's resistant in rectifying any underpayments, then quite often you'll see those matters referred to a court to be dealt with formally. Recent actions by Fair Work Ombudsman, a number of matters. We'll talk through a number of matters that have been referred to the courts to be dealt with, where there's been a significant underpayment found by Fair Work. There's one case, and most of these happened throughout September and October, where an advertising company's been fined $100,000 for underpaying a number of staff. Plus, in addition to that, they've had to make back payment of quite a significant amount. So we've also got a major retailer who has recently been fined $190,000 for underpaying a number of their trolley collection staff, and a childcare centre who has been fined $170,000 for underpayments to a number of staff, and potentially with that particular case it may put them out of business. So we're seeing quite significant penalties coming out of these sorts of matters. To illustrate a few other recent cases that have come about, specifically related to fast food and restaurant employers. We've had one cafe owner who was engaging overseas workers on student visas, who has recently been fined $40,000 for underpaying their staff. A bakery over in the eastern states, $22,000 for underpaying one of its employees over about an 18-month period. When you see these significant fines coming out of underpayment claims, generally The substantial fines are for businesses that have either been completely negligent of their responsibility in terms of paying their staff, so haven't taken steps to try and understand which awards cover their employees. In some cases, businesses have actually altered time records to make it look like staff have worked less than what they actually have done to try and cover up the underpayment. However, for example, with the childcare that was found to be $170,000 down with their payments for their staff, in that particular case, the business had actually taken steps to try and determine what award coverage the staff were using the right award, but had classified them under the wrong levels, and so were paying them at a lower rate than they should have been paying. And so they were still found to be in breach. You may have the right award, but if you haven't classified your staff under the appropriate levels, then you still may be at risk of an underpayment claim. So it's really critical that businesses understand exactly where their employees sit, even if they know what award applies. For franchise groups, the critical thing to remember is that whilst you may be part of a group, the businesses are still individually owned, and individual owners can be held personally liable in these matters. So the onus is still very much on the business owner to understand what their obligations are and make sure that they're complying. What we tend to see with these matters is if steps haven't been taken to try and understand what the obligations are, that the fines can be really significant, and quite often you'll see fines being substantially more than the actual underpayment itself. Just to give you an example, in a recent case with a group of service stations that were audited, one business owner was fined $150,000 for underpaying its staff by $89,000. So not only did they have to rectify the underpayment, but they also had to pay $150,000 in addition to that for breach of their award terms and conditions. There's a number of things happening in this space when it comes to underpayment at the moment that businesses need to be aware of. Firstly, Fair Work Ombudsman have a compliance campaign happening at the moment and for the remainder of the year, where they're going to be spot checking businesses specifically in WA in our southern suburbs. So they've pegged businesses across a number of industry sectors looking at compliance and specifically underpayment. And in light of some very recent cases to do with franchise groups, it's highly likely that those business types will be targeted as part of that campaign. Also, there's a bill before the Parliament that the Greens have recently introduced that is specifically focusing on recovery of unpaid amounts for franchisee groups. The idea behind it is that it's designed to provide some protections to employees that are wanting to raise complaints about underpayment with their franchise owners or their head office. So it's giving them abilities to go directly to their head office and make that complaint and protect them in that regard. It's also designed to put a greater onus on franchise head offices to assist franchisees to manage underpayment and make sure that they're complying. So it's still in bill form, but we're watching that space to see what happens with that. So the Employee Relations Advice Centre team are a team of employee relations professionals that provide phone advice and support to our employer members on a full range of employment matters. It can be anything from what is my award that covers me, what wages do I need to pay, when does overtime kick in, and what shift or penalty loadings that I need to apply to particular times when staff are working. But it can also be broader than that too. We deal with the whole range of employment issues and human resources matters, and we're there to assist and support businesses in any of those matters. We typically take around 10,000 queries per year related to award terms and conditions and compliance with those instruments. So that's around about 1/3 of all calls that we take, and certainly a lot of those queries are related to payment of wages and what employer obligations are, particularly with respect to awards.